Lord, if your lordships will note, Lord, this was a judgment which was delivered, my lord, by 5 judges. Lord, the judgment involved a challenge to the Maharashtra Agricultural Land Sealing and Holding Act number 27 of 61 and the amendments thereto. Vide several amendment acts, collectively referred to as the 61 Act, which was brought into operation from 26 January 62. The validity of the Act was challenged in 2660 petitions before the Bombay High Court. Now, I'm getting all these events from the majority judgment, recitation of rights. By a judgment dated 13th August 1976, a division bench of the High Court of Bombay, sitting at Nagpur, repelled the challenge in Vitthal Rao's case. The division bench held inter alia that the 1961 Act and the amendments thereto were not open to challenge on the ground that they were inconsistent with or took away or breached any of the rights conferred by Part 3 of the Constitution, since the acts have been placed in the 9th schedule by the Constitution of Amendment 17th Amendment Act and the Constitution 40th Amendment Act 1976. Further, on the ground that because of the promulgation of the emergency, the rights under Article 14 and 19 of the Constitution could not be enforced, the High Court also repelled the challenge to the validity of 31B itself on the grounds stated therein. But the High Court actually said 31B furthers the principle of the directive principles of state policy. But appeals were then filed against the decision of the Bombay High Court. Lord, the cause title there was Dattaraya Govind Mahajan. By a judgment dated 27 January, the Honorable High Court dismissed, this Honorable Court, the Supreme Court dismissed the same. Upon revocation of the proclamation of emergency, petitions were filed by the appellants praying for a review of the judgment in Dattaraya Mahajan's case. Inter alia on the grounds that the emergency had suspended several of their fundamental rights and grounds, which were otherwise open to them and could not be made by reason of the emergency. Some other fresh petitions were also filed in the Honorable Supreme Court. Accordingly, the matter came to be considered by the Honorable Supreme Court. The majority judgment delivered by Chief Justice Chandrachud for himself and Justice Krishna Iyer, Tulsapurkar and AP Sen recorded the challenge before it in the following terms. Now, Lord, I've extracted this. In these proceedings, so Lord, this was a direct challenge, is what I want to show you, Lordship. Lord, to 31A, 31B and 31C. In these proceedings, the main challenge now is to the constitutionality of Articles 31A, 31B and unamended 31C of the Constitution. The various grounds of challenge to the Principal Act and the amending acts were met on behalf of the respondents by relying on the provisions of these articles, which throw a protective cloak around the laws of certain description and variety by excluding challenge thereto on the ground that they were violative of certain articles of the Constitution. The reply of the appellants and the petitioners to the defense of the respondents is, as it could only be, that the very provisions of the Constitution on which the respondent relied for saving the impugned laws are invalid, since these particular provisions of the Constitution, which were introduced by later amendments, damage or destroy the basic structure of the Constitution within the meaning of the ratio of the majority judgment in Kesavanand Bharati. So, the challenge was a straightforward, basic structure challenge as far as we are concerned to 31C. From the above, it is evident that the challenge as far as Article 31C is concerned was to unamended Article 31C. It is also relevant to note that the judgment which had recently been delivered, this is to my Lord the Chief Justice's point, in Minerva Mills was also expressly noted by Chief Justice Chandrachud in paragraph 9 and 15, but I've given the references to your Lordship there. In paragraph 9, the judgment was noted with regard to section 55 of the Constitution 42nd Amendment Act, amending Article 368, and in paragraph 15 it was noted that Minerva Mills struck down section 4 of the Constitution 42nd Amendment Act. The challenge with regard to 31C was considered and dealt with in paragraph 52 to 54. As your Lordship says, there are only 2 really relevant paragraphs. That leaves for consideration the challenge to the constitutional validity of the unamended Article 31C. As we have stated at the beginning of the judgment, Article 31C was introduced by the Constitution 25th Amendment Act 71. Initially, it sought to give protection to those laws only, which gave effect to the policy of the state towards securing the principles specified in clauses B and C of Article 39 of the Constitution. No such law could be deemed to be void on the ground that it is inconsistent with or takes away or abridges the rights conferred by Article 14, 19 and 31. The concluding portion of the unamended article, which gave conclusiveness to certain declarations, was struck down in Kesavanand Bharati. 54. So, the one my lord, one plank of the reasoning was Keshavanand Bharati. Now, my lord, the second. Apart from this, so my lord, in addition to that, if we are right in upholding the validity of Article 31A on its own merits, it must follow logically that the unamended Article 31C is also valid. So, my lord, this was on parity of reasoning between 31A and 31C. The unamended portion of 31C is not like an uncharted sea. It gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in Clause B and C of Article 39. These clauses of Article 39 contain directive principles which are vital to the well-being of the country and the welfare of its people. Whatever we have said in respect of the defined category of laws envisaged by Article 31A must hold good, perhaps with greater force, in respect of laws passed for the purpose of giving effect to Clause B and C of Article 39. It is impossible to conceive that any law passed for such purpose can at all violate Article 14 and Article 19. My lord, it's sentiment expressed, my lord, the Chief Justice yesterday as well. Article 31 is now out of harm's way. In fact, far from damaging the basic structure of the Constitution, laws passed truly and bona fide for giving effect to the directive principles contained in clauses B and C of 39 will fortify the structure. We do hope that Parliament will utilize to the maximum its potential to pass laws genuinely and truly related to the principles contained in clause B and C of Article 39. The challenge made to the validity of the first part of unamended 31C therefore fails. Or just by way of summary. So, not two grounds. Not one is Kesavananda Bharati has already upheld it. But the second independent ground is that if we uphold 31A, agrarian reform, and other such similar laws, then surely on parity of reasoning, we must also uphold 31C. And not the very important observation, which I'll come to later on, Lord, where the learned Chief Justice says that how could a challenge based on 14 and 19 succeed against a law which is truly towards the purpose of 39 B and C? Not something which my Lord Justice Dhulia sort of echoed in the example and the discussion on 39B as well. If it's truly towards alleviating inequality, what is your possible challenge under 14 and
39B, 38.
38? Sorry.
And in this, the reasoning is given that it gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in clause B and C of Article 39. So because it is specific
and limited,
it is not the entire directive principle. Therefore, it is valid.
Your Lordship is perfectly correct.
It is not just because 31A and 31B have been upheld, therefore we are doing it.
No, Lord, I would agree.
The reason is this.
No, Your Lordship is correct, but perhaps
B and C, to that extent, fine. If you take the entire directive principles, no.
But for a specified purpose, namely
specified purpose is 39A, B and C.
B and C, Lord, it passes muster. So, Lord, independent reasoning. But that's what I wanted to impress upon Your Lordship. Not only Kesavananda Bharati, but independent reasoning. But some may say, so far.
Look at the language, just the sentence after that.
Please, my Lord.
It gives protection, as my brother just now read out.
My Lord.
Protection to a defined and limited category of laws which are passed to give effect to the policy of the state towards securing the principles specified in Clause B and Clause C of Article 39.
My Lord.
And these clauses of Article 39 contains directive principles which are vital to the well-being of the country and the welfare of the people. Just look at the brilliance of the articulation.
There is no doubt about
it. Unmatchable, actually.
Or I would say one thing, my Lord, that, or I said it the other day also, my Lord. This was an age of masterful writing, my Lord. And my Lord, in particular, my Lord, some of these judgments. But the bar was set very, very high for all of your Lordships, my Lord. Lord, I've attempted an analysis, my Lord, in Roman 5 and 6. Lord, from the concluding part of paragraph 53, it is clear that Article 31C was inter alia upheld on the basis of the ratio of the majority judgments in Keshav Nanda Bharati. However, the fact that this was not the only basis is also evident from paragraph 54, which by its lucid reasoning provides inter alia that Article 31C gives protection to a defined and limited category of laws. To both of your lordships' point, the lucidity as well as the limited nature of 39C. Pass for giving effect to the policy of state towards securing the principles specified in clause B and C of Article 39. That Article 39 was vital to the well-being and to the welfare of its people, and whatever was said earlier in the judgment with respect to defined category of laws envisaged by Article 31A must hold good perhaps with greater force in respect of laws passed for the purpose of giving effect to B and C of Article 39. The learned, I should say the Chief Justice, I'm sorry, Malul, went on to state that it was impossible to conceive that any law passed for such purpose could violate 14 and 19. Lord, in paragraph 55, the judgment also clarified. This is a very interesting clarification, actually, Lord. And Lord, it actually occurred to me, Lord, it has great bearing on the Folio point, but Lord, I'll leave that for now. Lord, in paragraph 55, the judgment also clarified that the individual examination of laws, Lord, I've not extracted it, perhaps I can read it to your lordship. The individual examination of laws inserted into the 9th schedule on or after 1973, which provided for earlier in the judgment against the basic structure of the Constitution, would become ocious if such laws fell within the scope of 31A or the unamended Article 31C. And accordingly, it would become unnecessary to determine whether they receive the protection of Article 31B read with the 9th schedule. So, Lord, what the learned judge said was this, Lord, that you don't need to check whether the law which is inserted into the 9th schedule is violative of 14 and 19 if it is already covered by Article 31A and by Article 31C. So, Lord, some powerful reasoning, my Lord, with regard to 31C. Now, Lord, I've only mentioned overleaf, my Lord, just as a matter of fact that there was a dissent in that judgment. My Lord, Justice Bhagwati, after delivering a dissenting judgment and Lord, Justice Bhagwati, delivering a dissenting judgment and reiterated that he had already given his reasons for subscribing to the order delivered earlier in his dissenting judgment in Minerva Mills, and that the same should be treated as forming a part of the present judgment. He expressly identified various portions of Minerva Mills' judgment as the reasons for making the order of 9th May 80 in the present case. Now, Lord, since it's a dissent, Lord, and in the interest of economy of time, Lord, we need not go into it, Lord. So, Lord, it doesn't have any legal effect. Now, my Lord, my comment on Waman Rao is as follows, my Lord, and my Lord, this may be taken as my submission on it, my Lord. Comment on Waman Rao in relation to whether it can be regarded as having decided the question of revival of unamended Article 31C. Waman Rao was concerned with the question of validity of the unamended Article 31C. In Waman Rao, the Act of 1961 was being challenged, inter alia on the basis described in the judgment above. As is evident from what is stated above, the challenge in all proceedings before the Bombay High Court and the Supreme Court were in respect of matters prior to the 42nd Amendment Act taking effect on 3rd January 1977. So, my Lord, in terms of temporal analysis, it was all before this amendment took effect. It is submitted that paragraph 3 of the order of the court dated 9th May 80, which held Article 31C unamended, is valid to the extent to which its constitutionality was upheld in Kesav Nanda Bharati and does not damage any of the basic or essential features of the Constitution or its basic structure. I paraphrase the order. Must necessarily be understood in respect to the challenge and grievances which were raised in the proceedings before the Supreme Court. But this is how I've tried to deal with it now, Malum. But it is well settled that judgments must be read as judgments in the facts of the case and not in abstract. the principle applies to judgments on constitutional law as well. It is further submitted that the judgment in Waman Rao must be understood in the context of the constitutional challenge that was made there, i.e., a challenge that the unamended Article 31C was in breach of the basic and essential features of the Constitution and stroke or the basic structure. This was the only challenge which was repelled, and the declaration of validity of unamended Article 31C in the judgment must be understood in this context. Not overly. It is submitted that a Constitution Amendment Act or an article of the Constitution may be held to be valid against a particular challenge by repelling that challenge, but unconstitutional on another challenge by accepting the grounds of the other challenge. The mere fact that the constitutional provision is held to be valid by repelling a particular challenge does not confer upon it a constitutional validity in perpetuity, which safeguards it against future challenges of a different nature.
You have to elaborate on this. What are you trying to say in this?
Madam.
6.
Yes, madam.
Submitted that a
Constitutional.
But may I read it again, madam? But this is my proposition to your lordships, madam. But I'll try to elaborate it a little further, my lord. May I just go through the note and then deal with it extempore, my lord, with your lordship? I'll try to actually deal with it further, because this is the nub of my argument to your lordships. Illustratively, to my Lord Justice Dhulia's point, this is how I've tried to explain it, because I understand, my lord, that this requires some elaboration. It is entirely possible that a constitutional provision may be held valid against a challenge under Article 19 by repelling that challenge, and yet subsequently be held unconstitutional against a challenge under Article 14 or 21. It is an admitted position and evident from the record that the Honorable Supreme Court in Waman Rao did not consider the validity of unamended Article 31C on account of the judgment in Minerva Mills holding Section 4 of the Constitutional Amendment Act unconstitutional, on the ground that it damaged the basic structure of the Constitution. So, Lord, this issue of revival was not present to the judges in Waman Rao at all. It is also evident from the record that Chief Justice Chandrachud, for the majority, repelled the challenge and upheld the validity of unamended Article 31C solely on the grounds stated in paragraph 53 and 54. As such, now this is my conclusion, Waman Rao has no precedential value whatsoever with regard to the present issue, and in fact, as from what is stated above, demonstrates that the challenge was on an entirely different basis. So, my lord, this is my attempt to grapple with the problem which your lordships presented to me yesterday. My lord, just a few comments on this, my lord. So, my lord, stepping away from Waman Rao, etc., just as a general principle of constitutional law, my lord, a constitutional provision may be challenged on various grounds. Or just illustratively, I've given your lordship an example of 19, 14, and 21. My lord, conceptually, my lord, I don't think, my lord, I could be said to be wrong, my lord, to conclude that one might succeed, another might fail. Lord, when one fails, or let us say an Article 19 challenge, Lord, the statement of validity by repelling that challenge is just that. It is to say that it is valid against that challenge, but not to say that it remains valid against other potential future challenges. So, my lord, I, for one, my lord, see little difficulty in accepting the conceptual position that an article which survives a 19 challenge may fall to a 14 challenge. Lord, there is another more elaborate aspect to this also. Lord, if we accept what is undoubtedly true, my lord, that our constitution is a living document and that our constitutional values change with time, Lord, it is entirely possible that a challenge made under a particular article of the Constitution, say 14, might fail in 1976, but may succeed in 2024. I'm not the leading example, of course.
Then we have to reconsider that judgment.
Your Lordship may have to, and therefore I come to that point that I am free of that difficulty because I'm before 9 of your Lordships. And those were 5. Yes, my Lord, it is entirely possible. It may require a comment on that judgment.
But we are again subservient to a decision of 13.
Yes.
I have something to, yes, ma'am. Your Lordship is right. So that Keshav Nanda problem, my Lord, is a problem. My Lord,
You know, if both Minerva and Waman Rao particularly was just based on a judgment of 5, of course we could have reconsidered it. But today Waman Rao admittedly says that the validity of 31C, the unamended 31C, has been upheld in Keshwanand.
no, my Lord,
That stares us in the face. So the only point then which we have to consider is this, that since Minerva struck down the entirety of Section 4 of the 42nd Amendment, which included 39B and C as well.
but that is a later part of my argument.
Yes.
Yes.
Does that part relating to 39B and C get revived? That's the only point.
Your Lordship is right. Lordship.
Because reconsidering now Waman Rao, that will not really
No,
arise because Waman Rao in turn follows, though of course they've given additional reasons, but it follows Keshwanand. And irrespective of the additional reasons in Waman Rao, we are bound by Keshwanand.
Lord, I accept what your Lordship says, and I didn't think your Lordship would say anything to the contrary. Lord, just by way of an interesting aside, my Lord, one of the judgments, Lord, it has a fascinating analysis of the doctrine of precedent. This is not quite the precedential point, but it speaks about how the Normans always regard the older law as the better law. If I'm not wrong, my Lord, once again, it's Justice Chandrachud's judgment.
But Mr. Anjali, you are right that a constitutional provision which has been upheld against a challenge on one particular constitutional ground, the validity of that constitutional provision can be considered by the Supreme Court itself
Of course.
on other grounds, Ali and Day. High courts can't do it.
Exactly.
The Supreme Court has upheld the constitutional validity under 19. High courts cannot say that, well, 14 was not considered for another reason as well, that 19 and 14 are now no longer treated as silos.
My Lord.
They all amalgamate with each
Yes.
other. And after post Cooper and Maneka.
Maneka Gandhi, they all bleed into
Right.
each other. Your Lordship
But
is right.
Supreme Court can certainly say that, well, in that case, the challenge was on the ground of legislative competence. We look at the fundamental rights challenge here. Second, a provision which is constitutional and that applies to a legislative provision on the date when it was enacted may cease to become constitutional later on, which was the principle laid down in Motor General Traders by
Yes.
Justice
Perfectly
Venkatramaya as the Lordship then was, and followed in Malpe.
My Lord.
Right, and that's how Malpe said that, look, this provision was valid when it was enacted in the Bombay Rents Act in 1947, but no longer valid now. Those two issues do arise. But now, we really, the narrow issue which we have to consider is this. What is the effect of the declaration of Section 4 of the 42nd Amendment
Perfectly correct.
as unconstitutional? Will that, in that sense, affect the operation of the unamended Article 31C?
Lord,
Your point really is this, that unamended Article 31C was confined to 39B and C. That was subsumed in the expansion. The entirety of the expansion is struck down. So where is the question of revival? To which possibly the answer would be that, look, the reasoning in Minerva, in that paragraph, which you come to in a later part of your note, I was actually preempting you because I was reading ahead of you. That discussion in Minerva is not in relation to the validity of 31C in relation to Article 39B and C. That discussion in Minerva is actually about this wide expanse now which has arisen, that all provisions, if a law is passed in pursuance of any of the directive principles, it's immune from 14 and 19 challenge. This they said was not impermissible. This they said was unconstitutional. But they were not for a moment. They couldn't have doubted. Keshwan and Bharti. And so were they purporting to doubt Keshwan and Bharti? They had to issue that declaration for the reason that there was no severability arising there, because it was one omnibus provision, or any of the principles in the directive principles. I mean, you take that too honestly in a matter like this. There are two.
It's arguable either way.
Open.
Of course, it's always arguable either way.
But it's arguable either way. But then, do we strike down? Do we say that when this is the constitutional history, that do we say that, look, now 31C in its entirety is
But let me
effaced.
show your lordship there the constitutional principles with regard to the declaration of unconstitutionality and on effect on substitution.
Now,
That's a
you
separate.
finished your Waman Rao part.
I
no?
finished with Waman Rao, and I think
Let's
your
go
lordship.
Minerva, because then,
Let's
once,
Minerva
then we
straight.
can go into the heart of the
Yes,
matter.
Lord,
And,
we
you know,
can. Straight away.
I don't think it'll
Straight away.
embarrass
Now,
you.
my Minerva also I've tried a lot to do a little bit of extraction for your lordship's convenience.
Yeah, actually, that's good because, you know, that's really the relevant part of Minerva.
So, my lord, this is page 99 onwards.
But the fact remains that in Waman Rao, whatever has been stated is subsequent to the judgment in Minerva Mills.
Yeah.
That is true.
Challenge is to a stage anterior to Minerva Mills. The bench is conscious of what they have stated in.
No, my lady is right. That is a difficulty in my way, but I'm trying to deal with it. Yes.
Stated.
Yes. Lord. That is actually the problem for me, Lord, which I'm trying to grapple with and deal with first. But would your lordship like to see Minerva for a second?
Yes, just see para 58 at internal page 10 of your note.
Yes, para 58 straight away, Lord. But can I come back to the rest a little later? Lord, straight at 58, I want to deal with that concession point also to my Lord Justice Rishikesh Roy's point.
Para 24.
Very well, Lord, whatever your
But
lordship.
you know, the thing is that concession now, I think
Very well.
it's pretty clear.
Very well.
But they say Mr. Palkhiwala conceded that the unamended Article 31C is valid.
He could not have done so
And
otherwise.
they say, and rightly so, because of, then they refer to Keshwanand.
Lord, I am content with that, Lord. Please come straight to paragraph 8 then. Paragraph 8. Lord, it is in this light
Yes.
that the validity of amended Article 31C has to be examined.
Just
But-
one second, just
please.
one second. Page 10, internal page.
Page 101, my Lord, I find.
Yeah, it's,
And para 801.
PDF 10, page 101.
58 of Minerva Mills.
Yes, my Lord.
101. 101.
Yeah.
It's all extracted. सबको मिल गया है?
Yeah, extract.
And this problem of pagination is it's a perennial problem. I've been trying to solve it myself, but there's something called Bates numbering, my Lord, which actually links it with the way that it is numbered in hand. I've not yet been able to solve it entirely, but I've been
I tell you now that I don't want to break the flow of your argument. This is a perpetual problem. You know, now we have
noticed.
electronic files in the Supreme Court. What we find is that the page with the lawyer's site of the electronic file is not the same as our page.
Yes, my Lord.
So I said, there is a technological problem.
but
We
there's
think in technology can be resolved. So we've resolved it. The only thing it requires a little discipline on the part of the lawyer.
Arrangement, it's how you arrange it.
What happens is,
Yeah.
the moment, say, an office report comes in, we have our digital files are divided into 3 segments. Volume 1 is the original paper book.
Well,
Volume 2 is what we call the additional paper book, which will contain the rejoinders, counters, rejoinders, interim application. Volume 3 is the record of proceeding.
well,
Now, when a new pleading is filed in Volume 2, the pagination of Volume 2 will change. When a new office report comes and pagination of Volume 3 will change. We email it to the lawyers automatically. They don't have to download it. It's in the lawyer's inbox. The trouble is, advocates on record, when they brief seniors, don't take the they don't take the trouble of looking at the latest uploading. They will have something 5 or 6 days earlier. Now last night I was sitting till late with my staff. I said, how do we find this solution? So now we are coming out with a solution called versioning. So the lawyer's copy will have and our copy will have the date, the time and the precise 14 hours, 23 minutes, 32 seconds on such and such a date. So we have to make sure that we are on the same version as the bar.
Right.
So it has a solution. It just requires a little bit of more discipline on the part of the bar as well to lift the latest versioning.
Right.
Okay.
I dare say, my Lord, in the
I share it in the hope that, this travels beyond the voices in this court and people all realize that this has been done now by the Supreme Court. So, the latest version.
Lord, paragraph 8. Lord. What paragraph 58 deals with the question of validity of amended Article 31C. In this light, it is in this light that the validity of amended Article 31. Please, my Lord, please.
The sentence starts, paragraph 58, it is in this light.
Yes, my Lord.
Can you read para 57
Of course, my lord.
in volume 5,
Yes, of course.
page 2079?
Certainly, my lord.
That may give us some
Certainly.
more clarity.
Thanks again.
That's always a peril of this.
Contacts with, it is in this light that the validity of the amended Article 31C has to be examined.
But allow me to read 57.
Please.
And I'm obliged to.
Please.
Or, would your lordship mind if I read 56 only?
Okay.
56 onwards. This, because it's beautifully written again. But the significance of the perception that parts 3 and 4 together.
Just 1 second.
Yes, bro. That's at page 2079. 2079. I'm grateful to your lordship, and I think it'll be much better if I read both of this to your lordship first.
Yes.
Yes.
May I? My lord, the significance of the perception that parts 3 and 4 together constitute the core of commitment to social revolution, and they keep together are the conscience of the Constitution, is to be traced to a deep understanding of the scheme of the Indian Constitution. Granville Austin's observation brings out the true position that parts 3 and 4 are like two wheels of the chariot. What my lord, the Chief Justice put to me the other day. One no less important than the other. You snap one and the other will lose efficacy. They are like a twin formula for achieving social revolution, which is the ideal which the visionary founders of the Constitution set before themselves. In other words, the Indian Constitution is founded on the bedrock of the balance between part Roman 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. The harmony and balance between the fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. Then 57. This is not mere semantics. The edifice of our Constitution is built upon the concepts crystallized in the preamble. We resolved to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, and political. We therefore put Roman Part 4 into our Constitution, containing directive principles of state policy which specify the socialist goal to be achieved. We promised to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, belief, faith, and worship, equality of status, and of opportunity and assurance that the dignity of the individual will at all costs be preserved. We therefore put Part 3 in our Constitution, conferring those rights on the people. Those rights are not an end in themselves, but a means to an end. The end is specified in Part 4. Therefore, the rights conferred by Part 3 are subject to reasonable restrictions, and the Constitution provides that enforcement of some of them may, in stated uncommon circumstances, be suspended. But just as the rights conferred by Part 3 would be without a radar and a compass if they were not geared to an ideal, in the same manner, the attainment of the ideal set out in Part 4 would become a pretense for tyranny if the price to be paid for achieving the ideal is human freedoms. One of the fates of our founding fathers was the purity of means. Indeed, under our laws, even a dacoit who has committed a murder cannot be put to death in the exercise of the right of self-defense after he has made good his escape. So great is the insistence of civilized laws on the purity of means. The goals set out in Part 4 have therefore to be achieved without the abrogation of the means provided for in Part 3. It is in this sense that Part 3 and 4 together constitute the core of our Constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of the Constitution. I'm deeply obliged to you, Lordship. Now
It is
58.
in this light.
No, yeah, I'm deeply obliged to you, Lordship. Now it's much better now, my Lord, to read 58. Because it is in this light that the validity of the amended Article 31C has to be examined. Article 13(2) says that the state shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of that clause shall to the extent of the contravention be void. Article 31C begins with a non-obstant clause by putting Article 13 out of harm's way. It provides for a certain consequence notwithstanding anything contained in Article 13. It then denudes Article 14 and 19 of their functional utility by providing that the rights conferred by these articles will be no barrier against passing laws for giving effect to the principles laid down in Part 4. On any reasonable interpretation, there can be no doubt that by the amendment introduced by Section 4 of the 42nd Amendment, Article 14 and 19 stand abrogated at least in regard to the category of laws described in Article 31C.
You will have to elaborate this.
I will. I'm obliged, Your Lordship. The startling consequence which the amendment has produced is that even if a law is in total defiance of the mandate of Article 13, read with Article 14 and 19, its validity will not be open to question so long as its object is to secure a directive principle of state policy. We are disposed to accept the submission of the learned Solicitor General, considering the two charts of the case submitted by him, that it is possible to conceive of laws which will not attract Article 31C, since they may not bear direct and reasonable nexus with the provisions of Part 4. But that, in our opinion, is beside the point. A large majority of laws, the bulk of them, can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of the state towards securing some principle or the other laid down in Part 4. In respect of all such laws, which cover an extensive gamut of the relevant legislative activity, the protection of 14 and 19 will stand wholly withdrawn. It is then no answer to say, while determining whether the basic structure of the Constitution is altered, that at least some laws will fall outside the scope of Article 31.
Back to para 54 of Waman Rao and
My
try
lord.
to reconcile.
Before you go to Waman Rao,
Yes, my lord.
can I just highlight three things in this
Please, my
particular
lord.
para?
Please.
Para 58, if you go to 2080,
Yes, my lord.
okay, at the
Yes.
last line in, on 2079,
Yes, my lord.
it then denudes Article 14 and 14 and 19 of their functional utility by providing that the rights conferred by these articles will be no barrier against passing laws for giving effect to the principles laid down in Part 4.
My lord.
So there are three observations in this para which are very crucial. So will be no barrier against passing laws for giving effect to the principles laid down in Part 4.
Yes, my lord.
So now they are saying that you are giving an immunity against a 14 and 19 challenge on the ground that the law is giving effect to any of the principles in Part 4. Second, now if you could just travel a little down, the startling consequence
Yes, my lord.
which the amendment has produced is that even if a law is in total defiance of the mandate of 13, read with 14 and 19, now what follows. Its validity will not be open to question so long as its object is to secure a directive principle of state policy. That's the second.
My lord.
They're looking at now the width of the amendment
Correct.
provision, that it gives effect to any of the directive principles. Third, a large majority of laws, the bulk of them can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of the state towards securing some principle of the other laid down in Part 4. Three very critical observations in this paragraph. So what they find as objectionable is that there is a complete immunity to an Article 14 and 19 challenge if the law has been enacted in pursuit of any of the directive principles. Earlier, before the amendment, it was confined to specific directive principles 39B and C. Now they say what is objectionable is that canvas of immunity is extended so long as it is in furtherance of any of the directive principles. These three observations in para 58 are very crucial. Now, if you go down and travel to para 59 and then 60 for a moment,
Yes.
60 is very important.
May I read?
Very
my lord?
important because it deals with
60
Article 13.
because 60 dwells on what is referred to, in those three sentences.
Yes.
Any one directive, some directive principle or the other. Now just see 60 for a moment.
May I read 60 for your lord?
Yes.
My lord, and I return to your lordship's point immediately after.
We only
Or it was
have to
repeatedly,
see.
para to 54 of
I-
Waman Rao.
Actually, my lord, what your lordship has said, I believe,
Pardiwala
has in one sense answered my Lord Justice Pardiwala's point. I believe my Lord Justice Pardiwala's point was, in 54, it was the specificity, the point which was made also by Justice Dhulia, of 39B and C, which allowed 31C to stand.
Right. So what Waman Rao then says, we'll go to Waman Rao in a moment, is that so long as that the ambit of Article 31C
Is narrow.
is narrow and tailored to Article 39B and C, it passes muster. Though Article 14 and 19 per se are part of the basic structure of the Constitution. Right?
Perfect.
What was objectionable in what was found to be objectionable in the 42nd Amendment in Minerva was that as opposed to a narrowly tailored immunity confined to laws in furtherance of 39B and C, you are expanding it to the entirety of the chapter on directive principles, namely part 4. Now see, para 60 will make that even clear.
Not-
60 makes it way. But that's why I highlighted those three.
I'm obliged, deeply obliged.
In para 58, where they refer to some article or the other, the entirety of part 4.
I'm deeply obliged.
Not just the para 60.
But can I say one more thing before I go to 60? Lordship permits me just a word. But all the cases, my lord, treat 31A, B, and C as one suite of provision.
Absolutely, one sweet.
Or agrarian reform was the real driving purpose of 31A and B, and then came C. So it was always conceived as a very narrow balancing act that was done in favor of directive principles against fundamental rights. To your, my Lord Justices, to both points actually.
Now let's see para
Yes,
60.
now para 60. It was repeatedly impressed upon us, especially by the Attorney General, that Article 38 of the Constitution is the kingpin of directive principles, and no law passed in order to give effect to the principle contained therein can ever damage or destroy the basic structure of the Constitution, a point made by Justice Dhulia
Yes.
this morning. That article provides that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may be a social order in which justice, social, economic, and political, shall inform all the institutions of national life. We are unable to agree that all the directive principles of state policy contained in Part 4 eventually verge upon Article 38. Article 38 undoubtedly contains a broad guideline, but the other directive principles are not mere illustrations of the principle contained in Article 38. Secondly, if it be true that no law passed for the purpose of giving effect to the directive principle contained in 38 can damage or destroy the basic structure of the Constitution, what was the necessity, and more so the justification, for providing by a constitutional amendment that no law which is passed for giving effect to the policy of the state towards securing any principle laid down? Yes, Lord. Perfect sense, Lord. Your Lordship is.
So really, Mr. Andarjuna, what the court is finding objectionable in Minerva is this expansion beyond 39B and C. So neither Minerva, and now we'll go to Waman Rao para 54 to deal with Brother Pardiwala's point. So what is objectionable even in Minerva? Minerva is not reconsidering, assuming Keshwanand was 5 judges and not 13. I'm just theoretically saying that. Then Minerva could have possibly reconsidered the validity of 31C all over again. They couldn't have done that in Minerva. But that apart, what Minerva is finding objectionable is not original Article 31C in its unamended form, but the amended provision which expands the canvas of 31C to cover all the directive principles of state policy.
With respect, Your Lordship has perfectly articulated.
Now, if you come back to para 54 of Waman Rao.
And when we see that, Your Lordship will see that there's perfect symmetry
There is
between
symmetry between
Minerva and Waman Rao. There is no asymmetry in the two at all.
Perfect symmetry between the two.
So, my Lord, if we go back, if Your Lordship
I'll
doesn't.
go back to 54.
My note.
Brother Pardiwala.
My note. For my Lord Justice Pardiwala's point.
That's all right. No.
But in fact, my Lord, that was the very point expressed from the Waman Rao point of view by Justice
You
Pardiwala.
have quoted 54, right?
I have. My Lord, it's at page 96. Roman 4.
Yeah, otherwise, may I say something?
Please, my Lord.
Because if you see the other directive principles, it speaks of village industries, cottage
Exactly.
industries, animal husbandry, living, what is that, wages,
Living wage.
protection of monuments, then protection of environment, all those laws will get immunity then.
But to my
That is why
lady,
it was struck down.
but to my lady's point, Lord, that is actually once again another aspect of this. The balance was lost. If you say that everything within part 4 will take primacy, what about the earlier part which says that the constitutional tension is a part of the basics
The balance is preserved by 31C in its unamended form.
in an unamended form?
Now, once we accept that as the prevailing, the prevailing doctrine post Keshanand and even post Minerva and Waman Rao, we'll go to para 54 in a moment. Then the only point which we have to dwell on is what happens about that slightly problematic area. It's not a clear area of the entirety of section 4 having been struck down.
but
That
this
is
only-
a problematic area, but then
This only clears the way for that argument.
do we then say that, look, it is a problematic area? Obviously, otherwise, we would not be laboring this point and, so many three referral orders. Then do we take a very strictly formalistic view of the law by saying that the moment section 4 was struck down, the entirety of 31C is struck down? That would be a very formalistic reading of the Constitution. I mean, we are a constitutional court. I mean, we have to pay due deference to our peers and predecessors.
Understood.
Who came in and said, look, 31C in its unamended form is valid in accordance with the social ethos. Then we are only left with this point. What is the effect of a substituted provision having been...
Lord, your lordship is
down?
perfectly correct. Lord, all of this was an...
Also bear in mind, this is not really an absolute substitution. You were right when you said it can be by way of an addition, substitution, repeal. This was really a substitution coupled with an addition. But it was not a total substitution. They just changed those three words. Article 39B and C, and said all or any
Or any of the principles.
But I will try to deal with those issues also. And
just read para 54 and then I think
we can go straight to that point.
you go to the last part, which
Yes.
is the heart of your submission.
Straight to that point.
And what is the effect of the declaration of section 4 as unconstitutional? Does that revive Article 31C?
Yes, very well.
And perhaps the simple answer would be that, look, once 31C in its amended form is declared to be null and void,
Well,
subject to your caveat that it's not obliterated from the statute book, the Constitution, it's still retained, but it's always then italicized. It's in that sense from the date of its enactment, unless it is made prospective, from the date of its enactment or adoption, the amendment to 31C is rendered non-est. If it is rendered non-est from the date of its adoption in 1976, then the prevailing position which operated up to the date of the adoption of the Constitutional Amendment is not obliterated, unless there was intrinsic evidence that Parliament intended to obliterate by the Constitutional Amendment the earlier position. In some cases, for instance, there may be a clear intent of Parliament that, look, we want to obliterate a constitutional provision prior to the date and completely substitute a new provision. That is not the intent of Parliament. Parliament wanted to extend the scope of the immunity, actually.
but I will address your lordship on that as well. But I have some thinking on that, but I will address your lordship. But your
So
lordship,
just show us para 54 and then you can go to that last part. now.
Perfect.
Then we'll call upon the other side.
yes. So, my lord, if your lordship will come straight away, my lord, to paragraph 54. But may I read it for you? Lord?
Should we quickly, then
54?
54, I think you've read, Jamshi, you wanted to read? 54 you have read. Now go to the last point.
Straight away.
That will take you just, the conceptualization.
Yes.
We want the conceptualization. Now we've
May
seen
I-
the law, the judgments and everything.
Just say, but just to complete this, just two words, my lord. My lord, the succeeding judgments, Lord Bhimji Sen's judgment. Lord
Deep Singh Ji is that.
Bhim Singh Ji's judgment. I'm sorry.
By the way, Mr.
Sir-
Bhim Singh Ji used to come here. He was unfortunately passed away I think a couple of years ago in COVID or post-COVID. Used to
During
be up
COVID,
here.
I
Yeah.
think there was a reference made.
Singh Ji had filed a public interest litigation, which I allowed, where he said that the army porters who serve in the border areas, they have no security of tenure. They have nothing. If a porter falls, if any of you have gone to Ladakh and you see those porters just near the border areas, they are with their mules, you know, and it's very treacherous. And he said, there's nothing. The man just falls, he's gone. There's nothing for his family. So we allowed his petition, asked the army to come out with a social welfare security net for, thanks to Mr. Bhim Singh. A very, puny sort of a person, used to come and make his point. But he headed the Panthers party.
Yes.
And the first judgment saying that compensation can be granted for a violation of fundamental rights is in Bhim Singh's. It was preceded by Rudul Saha was preceded by Bhim Singh Ji, where he was detained in Jammu and Kashmir in those days, and our court awarded some compensation, I think, to him. Then came Rudul Saha and, D.K. Basu and everything. Yes,
My
sir.
lord, just to complete that, my lord, the three judgments, my lord, Bhim Singh Ji, my lord Sanjeev Coke, and Basanti's case, my lord, they did not deal with a direct challenge to 31C. They all proceeded on the basis that it is valid today. And they were, my lord, in a challenge to the Urban Land Ceiling Act, a challenge to a part nationalization of Coal Mines Act, and a challenge to a different part of MADA as well. And of course, the Basanti judgment, my lord, was delivered by Justice Venkatramaya as he then was. But we don't have
Basanti
the
actually for a moment.
Mada, that is the 31.
MADA judgment.
Let's see Basanti because it deals with.
So, my lord, it is actually easily distinguishable, but we can see it, my lord.
Let's, because I think Basanti, because otherwise they will cite it, we might as well look at it.
Yes,
They can
please do.
show us the relevant part they are relying on.
Please do. But I noticed that we don't have the historical problem that we have with Justice Chandrachud here with my lady, my lord.
Where are these judgments? Which volume is that?
Basanti Bai is in which volume?
But
Just tell us. Actually,
Volume 5.
Dulya said, just give us all the three because you
Yeah,
have given us
very
earlier.
yes, I'll give your lordship all three. But
Bhim
just,
Singh Ji is in which volume and which page? Volume 5?
it's all in volume 5. But give me just one moment. I'll tell your lordship what pages.
Any of the juniors on your side also have the pages readily, can just tell us. Bhim Singh Ji is 2-4?
27. Basanti Bai, sorry.
Basanti Bai is at 2427.
Basanti is
2427. Lord,
192.
2294 is Sanjeev Coke. And 2192 is Bhim Singh Ji. Yes, Lord, 2427. But let me just show you. Just help me, where is it here? Or just give me a moment, please, Lord, just a minute. Relevant parts. Relevant part. Lord. Yes. Facility by.
Which is a relevant paragraph?
Yes, so would your lordship just like to see the challenge in Basanti by first?
Sure, that is
Why
on
it
page
is
2429.
2429, Lord. Lord, this appeal by special leave, Lord, it was against the acquisition of certain lands in Lonavla under different provisions of MADA. Lord, yes, chapter 5. This appeal by special leave is filed against the judgment dated 8 November 1983 in writ petition, by which the High Court declared subsection 3 and section 4 of section 44 of MADA to be void and gave certain ancillary directions. Lord, the facts are then stated, and then the question your lordship will find in paragraph 5. Lord, in paragraph 5 is at page 2432. May I? But in the course of this appeal, the parties have not questioned the correctness of the decision of the High Court as regards the facts which had been found against the respondent. The arguments were confined to the constitutional validity of subsection 3 and 4 of section 44 of the Act. Then, if your lordship would kindly go straight away to the discussion on 31C at page 2441, paragraph 13.
Para 13, 244.
2441. But even granting for the purpose of the argument that subsections 3 and 4 of section 44 are violative of article 14 of the Constitution, we are of the view that the said provisions receive the protection of article 31C. We shall proceed to test the validity of the argument, keeping aside for the time being the observation in Sanjeev Coke. Let us proceed on the basis of Kesavananda Bharati and Minerva Mills. Article 31C reads thus. Lord, clause B of article 39, which is relevant for our purpose. So they proceed on the basis that it was very much alive and well, as your lordship says. States that the state shall in particular direct its policy towards securing that the ownership and control of material resources of the community are so distributed as best to subserve common good. The High Court rightly observed at the end of paragraph 14 of the judgment following Sanjeev Coke that the expression material resources of the community should not cover so and so. But, however, it erred thereafter in reaching the conclusion that Article 31C was not applicable to the case for the reason that the Act did not contain a declaration that it was enacted to give effect to Article 39B, Roman 2, by undertaking development of commercial centers while providing housing accommodation. The authority was expected to make profits, and hence it followed that the power to acquire was not conferred with a view to achieving the directive principles of Article 39B. That was an important criteria in the decision-making of the High Court. And two, the object of enacting the legislation was obviously to provide wholesome civic life to the citizens and not distribution of material resources. We are of the view that each of these reasons is invalid and erroneous. First, Article 31C does not say that in an act there should be a declaration by the appropriate legislature to the effect that it is being enacted to achieve the object contained in Article 39B. In order to ascertain whether it is protected by Article 31C, the court has to satisfy itself about the character of the legislation by studying all parts of it. The question whether an act is in... Sorry. Yes, exactly. Exactly. That is the point which is made. It's an entirely different point from the point which presents itself before your lordships today. And it accepts axiomatically 31C to be alive.
They follow Sanjeev Coke and Ranganath Reddy. They
Perfectly.
follow Justice Krishnayer's dictum in Ranganath Reddy and say that it has now been adopted by a constitution bench in Sanjeev Coke.
Perfectly put. Lord, that is the significance of this judgment. Lord, I have actually dealt with these three judgments.
The minority of-
Signed by Sanjeev. They cited the minority in Ranganath Reddy and say it was followed in Sanjeev Coke and therefore they are now.
Yes, but Sanjeev Coke itself is a remarkable judgment, Lord, where more or less the minority reasoning is preferred over the majority.
So now,
So, Lord, that's it.
the last part
Last
now,
part is all that is relevant. Lord, I only want to point out I've dealt with these follow-up judgments at page. Lord, the Lord, there's, if your lordships will permit me, one beautiful line in Sanjeev Coke, Lord, where Minerva Mills is described as a
rhetorical beauty is there.
rare beauty,
Rare beauty.
and persuasive rhetoric. Lord, I have dealt with these follow-up judgments in page 105 of my note. Just for your lordship's convenience, it's there. But can I take your lordship now, my lord, straight away? All this was to clear the path to say that I can argue this point. Lord, it is, this point remains. Now your lordship will assess the strength of this point, my lord. Lord, it is dealt with by my note, which I had given to your lordship earlier. Lord, it is-
105, right?
Note 3, yes.
Oh, note 3, not in this today's.
No, but it's in the earlier compilation notes. Lord. Yes, Lord, volume 1B, I'm told. Lord, whether Article 31C is a dead letter and whether unamended Article 31C should revive. Now, Lord, I'll just explain the note to your lordship in a second. There are two parts to the note. Lord, the first is what is the effect of the declaration of unconstitutionality upon the statute? Or that is the first part of the note. The second part of the note is dealing with this peculiar type of legislative activity, namely substitution and what it involves. So now these are two parts of the note. Yes. I'll just wait for all of your lordships to pick up that. So,
That
is that page 38?
38.
But my learned friend, Mr. Devrajan, draws to my attention that I hope your lordships.
We don't
Come.
have, I think, anything
Oh, I see.
beyond 37.
37, the note ends at, no, I have 38.
I see.
There is 38.
Well, just
It is there.
sorry.
Whether Article 31C is a dead letter.
Yes, not whether it's a dead letter and whether unamended or stood revived. Now, Lord, if I take your lordships directly to paragraph 3, Lord, all of which is exactly what I've been arguing, or the judgment in Minerva Mills declared section 4 to be beyond the amending power of Parliament.
You are saying that once section 4 is declared unconstitutional, that can't be revived.
So, Lord, I'm saying two things. The effect of unconstitutionality by your lordships is not to excise it from the statute book. It still remains a part of the statute book. It requires legislative intervention to then actually delete it. And this is exactly what they tried to do in the 44th Amendment Act, if your lordships recall. Lord, the part which was struck down by Keshavananda Bharati, they actually moved to say delete it. But for whatever reason, that motion didn't pass the Rajya Sabha. So, Lord, parliamentary practice.
45th.
45th, sorry, 45th. 45th Amendment Bill. Lord, it's a curious thing, but it's the 44th Amendment Act. So, Lord, it seems that there was one bill which didn't become an act. But I myself puzzled over that. 44th Amendment Bill was moved. That part which was allowed resulted in the 44th Amendment Act. So, Lord, one bill around the way, Lord, has got lost, missing, didn't pass.
That part
Yes.
not passed.
Yeah. No, my lord, your lordship has observed that problem, my lord. I myself noticed that. I tried to understand it. So, my lord, this first part, my lord, the argument is in two parts. My lord, once Minerva declared section 4 to be unconstitutional, what was its effect on the statute book first? That's the first part of the argument. So, if my lady would kindly look at 3 onwards, or 4 onwards. It is submitted that the declaration by this honorable court did not and could not receive the unamended Article 31C. Sorry, could not revive, it should say. So, I'm so sorry, I misspoke. Could not revive the unamended Article 31C as stated and submitted below. Now, Lord, this is the reasoning about that declaration of unconstitutionality. When Section 4 of the Constitution was declared void, it cannot be said to mean that it was totally ineffectual and did not at all have the effect of amending Article 31C as contemplated in the 42nd Amendment. The substituted words continued to remain as a part of the Constitution, and here, my lord, I have illustrated. But see Article 368, my lord, I have quoted, thereupon the date of assent, the Constitution shall stand amended in accordance with the terms of the bill. So once the bill is passed, my lord, it effectively comes onto the statute book, and in the case of a substitution, in the place of the previous provision. There is a clear distinction on the effect of the statute when it is amended or repealed by a legislation and when it is struck down by a court for constitutional violation. So the two are different. Repeal is entirely different from striking down by a lordship's court. The effect of a legislation on the statute is a physical change. An express repeal, removing the statute out from the statute book. Parliament repeals, it's gone, it's deleted. An amendment makes physical changes in the statute, but a judicial decision does not make any physical changes in the statute. So I should say changes in the statute. It only places a particular meaning on it and leaves the statute on the statute book without any change. This difference is due to a clear separation of the functions between the legislature and the judiciary under our constitutional scheme. Note 7. No statute can go out of existence unless the legislature repeals it. The courts do not possess the power to make a statute or to repeal a statute. When a court declares a statute as unconstitutional, it is void. It is legally unenforceable, but factually, its existence cannot be wiped out by judicial declaration. In State of Bombay and F.N. Balsara, the Honorable Supreme Court had struck down Section 13 of the Bombay Prohibition Act 1949. This case dealt with a pre-constitution act. It was existing law on the date of the constitution. The question of the effect of its unconstitutionality, as so declared, came up first before a 3-judge bench in Pesikaka's case, Behram Khurshid Pesikaka versus State of Bombay. Justice Bhagwati, N.H. Bhagwati, held that the effect of the declaration of unconstitutionality, there was a slightly different view here, was not to enact a statutory provision or to alter or amend Section 13B of the Act. So, my lord, one thing I hasten to act. Now, my lord, we are speaking about its effect on ordinary statutes. One of the problems that we have had here, my lord, there is very little material on this point. And that has been noticed also in the NJSC judgment, which, my lord, I will be making some submissions to your lordship on. With regard to its effect on the constitution, my lord, is very little tried and decided, as I will show your lordship. But there is one or two, my lord, in my respectful submissions, persuasive indications.
After the provision is struck down,
Yes, ma'am. Sorry, ma'am.
whether they are bound to carry out the amendment also, deletion, addition, whatever.
Well, your lordship has raised a very good point. My lord, they may allow it to linger on in the statute book, as has actually happened and commented on by Justice Chandrachud, my lord, as he then was. My lord, to say it lives an italicized existence. So, my lord, when your lordship finds in the statute books, my lord, many of the parts of the statute in italics, your lordship will find a footnote there to say that actually it was struck down by this. Parliament has not taken the necessary step for
Whether the
actually.
Parliament is bound to do it.
Parliament is not bound to do it. Parliament may do it, Parliament may not do it.
For a layman, it is very difficult to understand.
It
The
is.
kind of argument being raised here,
Yes, my lord.
that the earlier has revived.
My lord.
So nobody knows what was there, not there. So
Your
how
lordship-
layman will understand this thing?
No, your lordship is perfectly correct. My lord, I would submit to your lordship that for the orderly development of the law, Parliament must do one of two things. It must either remove, sometimes, my lord, in the 9th schedule, what was happening was that once it was struck down, it was immediately inserted into the 9th schedule to revalidate it.
Yes, but
So,
some-
but there also, Parliament is fully conscious of the fact that it requires parliamentary action for revalidation.
is there, but
It is always done. Because striking it down leaves it hanging, but what do we do with it? But may I just return, my lord, to the note, my lord?
Because very rarely there would be a question that the striking down was bad in law at a future date.
Quite right, quite right.
They don't do anything about it. They accept it unless they abrogate that judgment by removing the basis of the judgment,
My lady is perfectly correct.
validation or something.
Like, I'll give you another example.
My lord,
Although it's not a part of the constitution, but section 303 IPC
my lord,
has been declared as unconstitutional by the Supreme Court.
my lord.
It still exists in the statute books.
Your lordship is,
Ineffective.
yes, ineffective, void actually, void.
Similarly is this post Minerva, the status of 31C.
Yes, your lordship is right. It's still there.
You can put it in an article somewhere. Effectively, it's nothing.
So, my lord, this requires a little, because the courts and parliament always work in tandem. At least the Supreme Court and parliament is to work in tandem. What the Supreme Court does, well, it may be accepted by parliament. Then you do away with it. You may not accept it, change the basis of it and revalidate it. But, my lord, parliamentary inactivity, in my respectful submission, results in the situation that we are in today. And it is difficult to see who can do it but parliament. So, my Lord Justice, Chief Justice put it to me, is this a technical point? Parliament can easily revalidate it. Of course it may. But, my Lord, Parliament in 2024 may take an entirely different view with regard to the insertion of an article which was done in 1972. It may delete it. It may revalidate it. It may bring it back in some other form. But these are all matters for Parliament to now decide. The baton, as it were, is handed over to Parliament to do what it will. And Lord, the unsatisfactory consequence of this, that yes, we are left without the article, Lord, is a logical sequitur if we accept the fact that this is something which is left for Parliament to do. Lord, I absolutely see the fact.
What is the logical sequitur of what you're arguing if the declaration of unconstitutionality does not efface the provision from the Constitution? It remains a part of the Constitution, but it becomes unenforceable. It becomes void and unenforceable.
Unenforceable.
Now,
That takes me to step 2.
what is the step 2 then?
So step 2 is that in the case of a substituted provision, what is remaining on the statute book is the unenforceable provision. That is actually, I'm glad your lordship asked.
In the
That is
case
surely
of-
the logical
Can you just
consequence of
say
this.
that again? In the case,
But in the case of a substituted provision which is declared unconstitutional, the same remains on the statute book, but is ineffective and is in fact void. And my lord, if your lordship were to push me a little further, my lord, I would have to say that there is no room for two provisions, one of which has replaced the other.
What they are arguing is the effect is that.
Is that exactly? But what my learned friend,
so really speaking, what you are saying is this, that when Parliament substitutes in its constituent power a constitutional provision, then the effect of that is that the original provision
extinguished.
is completely extinguished. That does not remain on the statute book because it's Parliament's power.
My lord.
But when the substituted provision is declared to be unconstitutional by a court,
My lord.
that substituted provision still remains on the statute
Very
book,
much so.
albeit it is unenforceable. So the declaration of the substituted provision as unconstitutional by the court will not revive the earlier provision because the court does not enact a law.
Lordship has put it perfectly, but if I were to slow your lordship's
We'll have to
process,
hear the other side on this.
but if I were to slow your lordship's process down by just one step, what I would say that the declaration of unconstitutionality, Lord, brings to an end your lordship's examination of that constitutional provision. Your lordships cannot even say it stands removed from the statute book. It is now handed over to Parliament, who must take the necessary action on it.
And if it doesn't?
But we have the situation which we have today.
No,
It's a dead
but
letter.
will there not be something like an implied revival, something like that?
No, but
But see, as your argument is actually very attractive.
my lord,
Philosophically, theoretically, it's very attractive.
my lord.
Yes,
Just a-
No, my lord, I understand the pragmatic problem. But I understand the pragmatic problem that I'm faced with, and I understand the fact that it's viewed as a technical argument.
Access between the two. There you have.
That point remains. But whatever else is there, that point remains. But let me try during the course of the argument to address that point once again. I have a separate section, but where I'm going to try to address that point once again as well. Yes. Please.
Propose what fell from my lordships, my lords. Today, by a process of interpretation, they want your lordships to do something which Parliament said it won't do. That may kindly be considered, my lords. Parliament said it does not want 39B and C in its old form. That's why the 44th Amendment Act did not bring it in. Though the bill contained it, the act did not come. So today, by process of interpretation, they want your lordships to bring in something which Parliament said it won't do, my lord. My lords may kindly consider this subject.
I am very obliged to my learned friend, actually. My learned friend,
Not an NJC case for that.
we are going to the NGSE case.
You are relying on that.
Yes, but I'm going to show your lordship the NGSE case.
Just read the Article 31C now, what sense it makes.
It makes no sense. Your lordship is perfectly correct, if I may say so.
If the deletion is deleted, whatever is struck down is ignored.
It is
there
actually completely emasculated.
no sense here.
The only way it can make sense is if the old revives.
Yeah.
That is the only way it can make sense.
If you pick up the book,
Yes,
then there is only part 4.
there's only part.
39 BC, as it was earlier.
Your lordship is right.
But then we'll have to read it.
But and your argument has a fiction implicit in it.
Well,
That you see, normally when Parliament say substitutes an original provision,
well,
that substituted provision ceases to be on the statute. Right? Forget this particular case. When Parliament substitutes a provision in its constituent power,
yes.
the original provision ceases to exist. It ceases to be on the statute book. When the court declares or strikes down the substituted provision, it continues to remain on the statute book, albeit it is
Ineffective.
rendered unenforceable, null and void.
My lord.
So therefore, according to you, and that is following the doctrine of separation of powers, that it is only Parliament which can efface a provision from the statute book. The court can only strike it down as unconstitutional. So when the court strikes down a provision as unconstitutional, that does not lead to the revival of a substituted provision which is exclusively within the domain of Parliament.
And there, my lord, your lordship once again has put it perfectly. But I would just add one or two perhaps logical extensions to that.
That's your argument, really.
That is my argument. But my learned friend, Mr. Devrajan, raised an excellent point, my lord. Parliament may express its parliamentary intent at that stage. It may say that I accept the advice given by the courts. I accept the fact that in fact it should go and it is unconstitutional.
For the court to revive a provision, according to you, is for the court to exercise a constituent power.
My lord. My lord. This in a nutshell is exactly what I've been saying.
You were not here yesterday, Mr. Devedi was making this point,
I heard it.
that it's just one exercise. It's not that if the 39th BC will not come, because it becomes void ab initio.
Yes.
And if it is void ab initio, the 39 BC will automatically come, as if it was there in the statute book.
Yes, my lord. I heard my learned friend, my lord, and my lord,
Just because.
I have got some way of dealing with that, my lord. If your lordships permit, I'll just come to that at the conclusion of this. My lord, I want to deal with that in a separate way, my lord. About the effect of that unconstitutionality and the fact that it relates back to the date of origin of that particular constitutional provision. But I have some thinking on that also, because I heard, my lord,
It goes back to the original.
it is well settled that when your lordships declares it's void, it relates back.
Unconstitutionality relates back.
Relates
to,
back.
The date of the 42nd Amendment.
So, yes, my lord, I accept that, but there are just two academic possibilities. My lord, one is that it relates back to 1972. That's a possibility. Well, that's all I'm saying, because what has happened is that it's a 72 provision amended from time to time, because another problem is take the 44th Amendment Act. 44th, why should it not relate back to the 44th Amendment Act then? Why only the 42nd Amendment Act?
Well, now the amendment of the 42nd Amendment, was it retrospective or it was prospective?
Prospective. I think it has always been understood thus, but that's Waman Rao. That's exactly what Waman Rao says.
Probably this void has been noticed by a foresight in Waman Rao, and they fall back on Keshwananda Bharati.
To say it is
Say
that.
that the unamended provision was upheld in Keshwananda Bharati, and therefore they say that it is still alive and kicking.
Well, my lord, I have had a similar thought about Waman Rao, because but I wonder sometimes what was the contribution of Coelho, because Waman Rao came so close to saying that 14 and 19 is basic structure. It just didn't say it in a sentence. And that was in 1980. So, my lord, the contribution of Coelho of 9 judges in 2017, seven, what was adding just that one few more words to nail it to the mark.
Even if 14 and 19 are part of the basic structure, as we will have to now proceed on the basis of their being a part of the basic structure, that does not still dilute the rationale of Keshwan Bharati, which is that it is not really a widespread or total, destruction of the basic structure.
It's a balance.
It's a balance, and therefore it is valid.
It's a balance. And Coelho is still relevant. What I had mentioned it to your lordship on that Lord Coelho should not be read as an absolute proposition to say that the minute you come against 14, it is something which will be struck down. Lord, 14 is a nuance. At 14, 21 are nuance. Lord, we must apply the essence of that to the question. So it's just an oblique infraction. Lord, may or may not result in the statute being struck down. But to the pith and the substance of 14, Lord.
So really your argument which they will have to meet is in two steps. First, that when Parliament adopted the 42nd Constitutional Amendment, the effect of the 42nd Constitutional Amendment was that original Article 31C ceased to be on the statute book. Two, when the amended provisions of Article 31C were struck down by the court in Minerva Mills, the provision does not get effaced from the statute book. It remains on the statute book, but it is unenforceable.
It has lingered on as a dead letter.
Third, the declaration of unconstitutionality by the court will not lead to a revival of original Article 31C for two reasons. Bracket 1, the court, by the declaration of the substitution of the provision by Parliament in the 42nd Amendment, had effaced the provision from the statute book. And 2, the court being treated to have revived the original provision will be again an act of a constituent power, which is not open to the court. I think that really is the
Your Lordship has
logical,
perfectly encapsulated Lordships to consider. Lord, I'm a little adrift here because, my Lord, I find no basis for one or the other. But, my Lord, when the court declares the provision unconstitutional, it does so taking the provision as a whole, because that's the only provision available to it. And therefore, my Lord, to what point does the unconstitutionality relate back? Or that is how I was attempting to do it, my learned friend Mr. Divedi's argument. It is not clear to me that it should go back only to the point at which the amendment made, because that point is no longer a point of significance, because it has now become entirely a new provision as of the date on which it was incorporated. There is only one provision. So what is not clear?
There's only one provision which is left, that 31C post the 42nd.
Exactly.
According to you.
But it is not like
The original provision was completely wiped out when it was substituted. And according to you, the declaration of unconstitutionality will not amount to a revival of the original provision, for the reason that has to be in the exercise of the constituent power, which the court does not wield.
The constituent power is the main point,
Read
actually.
the point. We call upon the other side now.
But shall I show your Lordship the authority on the topic before lunch?
Just quickly, you can
Quickly.
show us in 5 minutes.
Quickly.
Then we'll have to get the other side. We have to wrap up today.
Yes, I fully understand, but very quickly. But my learned friends also want to say something.
Now we have to go to the other side.
There's one addition, there's one additional
Let him
issue
come,
I can
let him
take,
argue. Let him-
as little
The
time.
link is also broken. Yes.
Look, I'll run through my note.
The birthday upheld the ornament.
Summarize that. I'll summarize that. If I don't.
Share the authorities and then you can briefly dwell on Coelho also.
I've actually-
Briefly, you can tell us so that they have a full, otherwise, again, we'll be calling upon.
Very
them.
well. But if your lordship just sees my note, I've extracted it once again.
Yes.
What page 40?
Page?
40, 40. Lord, PDF 40. Just one authority which was very good, which is not there. I'll just show your lordship from the compilation. But first on the effect of the declaration of unconstitutionality. But please see from paragraph 9 onwards. I'll finish this in 2 or 3 minutes. Paragraph 9, page 40. But, in the Constitution Bench decision of B.K. Pesikaka, Justice Mahajan for himself and Justices Mukherjee, Masan, Hassan and Bose held as follows. The result, therefore, of this pronouncement is that the part of the section of an existing law which is unconstitutional is not law and is null and void. For determining the rights and obligations of citizens, the part declared void should be notionally taken to be obliterated from the section for all interests and purpose, though it may remain written on the statute book and would be a good law when a question arises for the determination of the rights and obligations incurred prior to 26 January 50. Justice Das in the minority said this: no part of the section is obliterated or scratched out from the statute book or in any way altered or amended, for that is not the function of the court. The judicial declaration that a part of the section is unconstitutional and void only nullifies that offending part in the sense that it renders that part ineffective against the inapplicable to a citizen who consumes or uses, or in that case, liquid medicinal preparations, so on and so forth. Or in another judgment, my lord, which puts it very well, my lord, which is the Sundaramaiah judgment, my lord, dealing with the Post-Constitution Act and after considering the judgment in Pesikaka, my lord, it was held this. Thus, a legislation on a topic not within the competence of legislature and a legislature within its competence but violative of constitutional limitations have both the same reckoning in a court of law. They are, both of them, unenforceable. But does it follow from this that both laws are of the same quality and character and stand on a different footing for all purposes? This question has been the subject of consideration in numerous decisions in American courts. Oh, I'm sorry.
And the preponderance of authority in favor of the view.
And the preponderance of authority is in favor of the view that while a law on a matter not within the competence of legislature is a nullity, a law on a topic within its competence but repugnant to the constitutional prohibitions is only unenforceable. So you may have two views about what is their effect depending on what was the type of challenge. Now, my lord, or some high scholarly authority, my lord, what Mr. Sirvai, my lord has summarized the law on this point as follows. So, my lord,
The other is on.
Lord, the practice, I believe, is that never to cite living authors in this court. Lord, when a court declares a law to be unconstitutional, that declaration does not repeal or amend the law. For to repeal or amend a law is a legislative and not a judicial function. And my lord, then the next, my lord, authority, my lord, Khairiti Lal's case, my lord, Justices Fazal Ali Jaswant Singh, my lord, and approved by Justice Deshpande, is in the dissenting judgment of, approved the dissenting judgment of V.S. Deshpande and followed the same line of reasoning on the following lines. On a consideration of the circumstances, facts and authorities discussed above, in our opinion, the following legal propositions emerge. When a statute either as a whole or a part is declared void, it means that the portion which is declared void is ineffectual, destitute of any legal effect and not binding on the parties. Nevertheless, the Act remains on the statute book for the consideration of legislature in order to repeal or amend the same and for using it for some other collateral purpose. Number, that's the first part of it. Now the second part. So not the substitution part. Actually, what happens when you make the substituted law?
Now, what had Section 4 done? What was declared unconstitutional was Section 4.
My lord.
What had Section 4 done?
It had widened the...
Had it substituted and widened, or did it only...
But it had substituted in my respect. So, substituted and widened is not wrong. But widened by substitution is what I would say. But I think it is very difficult to see
So the substitution could not have been divorced from the widening, right?
But
4 did
I
two
would say
things.
that.
Section 4 did two things. It substituted the earlier provision and it widened the earlier provision.
The whole point of the substitution was the widening,
Was to
but it
widen
did
it.
so by the
Was
act
to,
of
was to
substitution.
widen it.
Yes,
Now, if that has been declared unconstitutional, Section 4 is declared unconstitutional by that operative part in Minerva,
yes.
right? What is the consequence then?
But the consequence is that actually Article 31C altogether is unconstitutional and remains a dead letter till such time as Parliament steps in and takes the necessary legislative activity. But that is the, and Lord, I hasten to
But
add,
the substitution was for the purpose of widening.
but my Lord, because of the fact that in widening you've obliterated the old section, but that is the part of my note that I just come to now. That is the
Not
legislative
also
process.
look at it in a slightly different perspective, that the substitution was not for the purpose of obliterating, but the substitution was for the purpose of widening,
I follow your Lord.
right? That Parliament never intended to dilute the protection under 39B and C. They wanted to really make that protection on 39B and C plus the other provisions of the directive principles, right? So the purpose, in a given case, Parliament may want to obliterate the provision completely and then substitute, okay, which was actually the NJSC case. But here, this was not a case of obliteration. What Parliament intended to do was to expand the ambit of the protection. Now, therefore, it was not a substitution and obliteration per se, but a substitution and expansion. Now, if Section 4 is declared to be invalid on the ground, primarily or exclusively, that the expansion was invalid, and conscious of the fact that the original provision had been already declared to be valid, then will this doctrine apply in a situation like this?
But let me try to answer that, my Lord. Because your Lordship has, my Lord, once again, my Lord, raised a point, my Lord, that must be considered. My Lord, when the scope of the article stood expanded, I asked myself one question. Could it be simultaneously also considered to be narrowly in the form of its original form? The answer must, that's the first step of my reasoning. The answer must surely be no. The article now stands in expanded form. But I want to also take the converse, my Lord. Let me assume that the article was originally in expansive form, and by the amendment it was narrowed down. But in my respectful submission, the same would follow, that it is now only the narrower interpretation that has any force. But it is very difficult to view substitution as a single stage process. And that is the point. I'm glad your Lordship asked me this question. It is always a two-stage process, which is exactly what the authorities say which come. The first is deletion of the original provision, and the second is to insert the new language. Now, my Lord, there is some inexorable sort of consequence of that. That is the argument on the other side. I will deal with
That
that.
cannot strictly apply, Mr. Andarjana, to a situation like this, where the deletion of the original language is not the purpose of the substitution, because the original language gets incorporated in the new provision.
I understand. Your Lordship has raised a very good, my Lord, conceptual problem,
So,
conundrum.
you know, there may be a.
So, my Lord,
Using spaces with the same ink.
what's it? So, my Lord, to your Lordship's point, my Lord, 39 B and C remain within the expanded conception of
So
funding.
we got your point.
Yes.
The moment that Parliament, in its constituent power, substituted and expanded the words, expanded the protection of 31C, the original provision was completely knocked off the Constitution.
Deleted.
Thereafter, when Section 4, which substituted and incorporated the new provision, is declared as unconstitutional, then according to you,
There is nothing to go back to.
the substituted provision doesn't get revived, because that substitution has been attained finality by, though it happens by the same act of the legislature in its constituent capacity. According to you, the first part attains finality. The declaration of unconstitutionality attaches to the latter expansion. That will not result in revival, because revival is the constituent power. I think we'll now close it at that and call upon the other side.
Very well. But may I just indicate 2 minutes to your Lordship?
And also see, I think Zile Singh's case, that it is written with the same ink on the.
I wanted to show your Lordship just that.
When the substitution takes place, the original is effaced.
But please look exactly at that.
Singh's case.
Lord, it is, I put it through another case, but the pen and ink theory,
Where is
exactly
that?
the point.
Where is that?
Paragraph 19 and 20.
At page?
Page 43 and page 43. But the act, just allow me to read this more before we close. The act of substitution in effect consists of two steps. First, the old provision is made to cease to exist. Next, the new provision is brought into existence in its place. Even if the new provision be invalid, the first step, that is the old provision ceasing to exist, is not undone. It remains in effect, and it is for this reason that the old provision cannot revive. This is now firmly established by the following decisions, not all settled authority on the topic. Now, to the pen and ink theory. But paragraph 20. The pen and ink theory first set out in the judgment of Justice Bose in Shamrao Parulekar, where it held that but the rule is that when a subsequent act amends an earlier one in such a way as to incorporate itself or a part of itself into the earlier, then the earlier act must therefore be read and construed, except where that it would lead to a repugnancy, inconsistency, or absurdity, as if the altered word had been written into the earlier act with pen and ink, and the old words were scored out so that there is no need to refer to the amending act at all. This is the rule in England, see Craze on statute law. It is the rule in America, see Crawford on statutory construction, and it is a law which the Privy Council applied in Keshoram Podar and Nandulal Malik. Bearing this in mind, it will be seen that the Act of 1950 remains the Act of 1950 all the way through, even with its subsequent amendments. Therefore, the moment the Act of 52 was passed and Section 2 came into operation, the Act of 50 meant the Act of 50 as amended by Section 2. That is to say, the Act of 50 now due to expire on 1st October 52. Therefore, such judgment has been followed. Lord, in this, Lord, and I might have missed my lady's judgment, but I'll check that and update it as well.
Singh versus State of Kashmir.
I'm obliged.
Jammu
I
and
will
Kashmir
do that
versus-
also. But just one last word I want to have before Your Lordship goes. Lord, I know that one way of viewing my argument is to say that you have raised a point of high technicality, but I'm conscious of that. But, my Lord, in my respectful submission, the correct way to view the argument is that it has raised an important point with regard to the effect of unconstitutionality and to the separation of powers. But it raises 3 points really. But the effect of unconstitutionality on the judgment, Lord, the parliamentary procedure involved in substitution, and thirdly, Lord, what is the constituent power and whether this type of action, the revival, is something which resides, Lord, with Parliament and not with the courts. Lord, the consequence of me being right, Lord, is hardly going to result in some sort of constitutional chaos, Lord, as was the case in the NGAC judgment. Lord, for 22 years, Article 31C was not even on the statute book. Lord, Chief Justice Chandrachud's observations in Minerva Mills, namely that you don't need 31C if the law is correctly made towards the purpose of 39B and C, because a challenge under 14 and 19 could then never survive. So, Lord, in my respectful submission, Lord, it would be appropriate that Parliament expresses its will by appropriate legislative action with regard to 31C. Well, I'm deeply obliged to Your Lordships. My learned friend, Mr. Parekh, wants to say a few words, Lord, and will not keep Your Lordships from lunch, I'm promised.
There was one third issue, Lordship. I'll finish by 1 o'clock. My Lord, there was one third issue which has been.
30 seconds now. You've heard.
No, my Lord, I just want to point out one issue. There is a third issue which is specifically that we'd argued, 5 judges referred it to 7, which is on Sanjeev Coke. Sanjeev Coke does 2 things. It does not only confer or follow the dissent in Ranganath Reddy, it also follows the dissent in Minerva Mills. So Sanjeev Coke does 3 things, and we specifically raised it in para 17 has been doubted. I just want to indicate, and on first principle I'm saying, what Sanjeev Coke does is 3 things. First, it doubts Minerva Mills specifically, but says that because the review petition is pending, we are not saying anything further. But it follows Minerva Mill dissent, saying that once 39B is in, Article 14 is out. And that is an issue that we specifically took up in Coelho to argue that even if it is protected in that case under the Schedule 9 of under Article 31B, 14 is not fully out. It may be a higher threshold, basic structure issue may be involved, but Article 14 is not out, and that's para 17 is what we challenged of Sanjeev Coke to say that the intent of 39B is not to make arbitrary law or make it in a manner that is discriminatory. And therefore, Coelho specifically said that 14, 19, 21 is imbibed in the whole constitution. And therefore, even if you're seeking to go ahead with the purposes of 39B, the constitution can never be said to intend that you do it in an arbitrary manner. And therefore, it may be a higher threshold, which may be a combination 14, 19, 21, or that 14 which affects the basic structure. 14 is still available. And therefore, we challenged specifically 17 of Sanjeev Coke, and I wanted to point that out and make 2 or 3 submissions because today we are on first principle. My lords, if it was a smaller bench holding that what is the effect of Minerva Mills, my lords may proceed in a different manner. But today, as 9 judges, my lords can certainly say, and even today find that Minerva Mills was right, or what is the impact of Minerva Mills, and you hold the whole thing. And that again, Mr. Andhyarujina pointed out, the series of judgment, now 2 judgments of 9 judges, both in Puttaswamy and Coelho have said that Constitution is a living document. From time to time, you may interpret it differently. And therefore, we want to raise this specific point, one on first principle, since it's open to my lords to confirm Minerva Mills or vary it or whichever you like. My lords can today hold, and we don't have to strictly go by the interpretation, what did Minerva say, what is the effect. Today, my lords are in a position where my lords can today say that we find that the amendment is bad and therefore it must go. Because if Article 14 is the essence of the Constitution, then even if you want to achieve the purposes of 39 B and C, you cannot do it in an arbitrary manner. You want to take away my property, you cannot do it in a discriminatory manner. You must follow some process. Even if you want to take over coal mines, etc., you cannot say, I do not like Mr. X or Y or Z, and therefore I only acquire your property and next door I do not. And that's the consequence if my lords holds 31C. And much water has flown down the Methi River, if I may say so. Article 31A is there. The A, B, C, none of them were there in the Constitution. A protects all agrarian reforms. B protects anything put in the 9th schedule. 31C today is irrelevant completely because if anything the parliament wants to protect as a matter of 31A, it can protect it. If anything has to be put in the 9th schedule by a constitutional amendment, they can put it in the 9th schedule. And Coelho now protects me that maybe a higher standard, but 14 is still available to me, even if you put it in the 9th schedule. So therefore, 31C today has no substance, and my lord sitting in a combination of 9 judges can certainly decide that. And therefore, our submission is that para 17, and if my lords permits, that's really all I want to say, but I wanted to show a few paragraphs of Sanjeev Coke, because it says these 3 things as I pointed out, and para 17 is what we had challenged. If I may, if my lord permits, page 2294 of volume 5 is where Sanjeev Coke starts. My lords, page, if my lords come straight to page 2308, volume 5.
What para is it?
It's para number 13. It starts at 2307. 3 paras, my lords, I'm seeking permission to read, and then I'll close. Paragraph 13 starts at 2307. My lords have. The Keshwananda Bharti case, the court expressly ruled that Article 31C as it stood at the time was constitutionally valid. No doubt the protection of 31C was at that time confined to law giving effect to the policy under B and C of Article 39. The Constitution 42nd Amendment Act, the protection was extended to all laws giving the effect to all or any of the principles laid down in Part 4. The dialectics, the logic and rationale involved in upholding
2307.
2307, it starts at the bottom, last paragraph.
Para 13. Yes, you can
Large.
start.
First, it cites Keshwananda Bharti upheld the unamended 31C. Then my lord, that's 2308.
Yes.
My lord. By the Constitution 42nd Amendment Act, the protection was extended to all laws giving effect to all or any of the principles laid down in Part 4. The dialectics, the logic, the rationale involved in upholding the validity of 31C when it confined its protection to laws enacted further to 39B and C should uncompromisingly lead to the same resolute conclusion that Article 31C with its extended protection is also constitutionally valid. No one suggests that the nature of the directive principles enunciated in other articles of Part 4 of the Constitution is so drastic or different from these directive principles B and C of 39 that the extension of constitutional immunity to laws made to further those principles would offend the basic structure of the Constitution. In fact, no such argument appears to have been advanced in Minerva Mills case, and we find no discussion and no reference whatsoever separate to any of the distinct principles enunciated in the individual articles of Part 4 of the Constitution of Minerva Mills. The arguments advanced and the conclusions arrived at both appear to be general, applicable to every clause of Article 39 and every article of Part 4, no less clause B and C than the other clauses. We wish to say no more about the Minerva Mills case, as we are told that the pending review petition.
They doubted Minerva. They had to refer it to a larger bench. They couldn't have said this in the face of Minerva.
I'm grateful, my lord. And that's what we pointed out, that this is most improper, because sitting there, in fact, they are, and I did not read all those paragraphs because of paucity of time. In fact, they quote the entire dissenting judgment, in this case, from Minerva Mills. And therefore, also I'm urging that this honorable court in this combination may confirm Minerva Mills, because it's too late in the day to now say Minerva Mills was wrong. And in fact, Sanjeev Coke doubts that. Then, my lords, para 15 onwards, and again, paucity of time, I'm not reading 15, 16. If I can come straight to 17, 17 is what we are. Because no, not confirm in the sense that only Sanjeev Coke doubted the correctness of Minerva Mills, saying that issue doesn't arise. They say that it is obiter. There are findings.
In fact, in para 16, they say we broadly agree with much what has been said by Bhagwati Jay in the extracts.
Lordships, I'm deeply obliged, which is why, in fact, this judgment seems to suggest that the dissent is correct. And there are findings which say that Minerva Mills findings are obiter because they didn't arise. And therefore, it would be appropriate today, in 2024, my lord, at the stage of constitutional history we are at, to confirm that Minerva was absolutely right, that both 3 and 4 are part of the same chariot, as my lords have called it, and both must work together. The aim in Part 4 must be achieved through constitutional means of Part 3. You can't say I jettison Part 3 because I have some great objective to achieve. Therefore, you can't say I like industrialist XYZ, and therefore I'll acquire their property because it's still 39B, but I don't like A by ABC, therefore I will not. Article 14 is that. There's nothing more to Article 14. It must be non-discriminatory. You can't pick it at your whims and fancies. And therefore there are multiple observations here which say Minerva Mills is only obiter. There is no finding there. And that, my lords, may clarify. That's all I was saying. But after that, my lords may see 14, 15 onwards is the second question, which is finally decided in paragraph 17. And this is what we were challenging, and that is what 5 judges, when they referred, are also referring to. And that's why they were waiting for Coelho. And this is, if I can point out, para 17, page 2312. Just this last para, 17. We are firmly of the opinion that where Article 31C comes in, Article 14 goes out. We are challenging this, my lords. There is no scope of bringing in Article 14 by a side wind, as it were, that is by equating the rule of equality before the law of Article 14 with the broad egalitarianism of Article 39B, or treating the principles of 14 as included in principles of 39B. To insist on nexus between the law for which protection is claimed and the principles of 39B is not to insist on fulfillment of the requirement of Article 14. Now, much water has flown down the river since then, my lords. I would submit that today, my lords may hold that certain principles of 14 certainly, which will in fact impact the basic structure, can be a ground to challenge, even if my lords holds that 31C is there, 39B is there. Even then, certain principles, and that is an issue that we specifically raised and was referred, and 5 judges and 7 judges therefore referred to these issues. Sanjeev Coke, higher Coelho, that's why they said wait for Coelho. And that's the logic in which this. So therefore, my lords, today I would submit that my lords may hold and my lords can hold that Article 14.
Article 14 goes, you have read that particular paragraph.
Gotcha.
Article 14 goes, Article 19 goes, if a reasonable nexus is established
Gotcha.
between the statute and 39
Gotcha.
BC.
Gotcha.
In that context, it is saying that Article 14 goes.
Gotcha. Therefore,
There is
no
not a sweeping remark like
no
that.
difficulty, Justice Dhulia is absolutely. But no, that's not. That's why after Coelho, that is not the law to this extent, and that's a submission that 1419 at a basic level may go, but if it amounts to affecting the basic structure of the Constitution, 1419 will still remain for a challenge, despite a protection from Article 31C. And I hope I've made that point clear. It may be a higher standard. It may not be the normal standard of 1419. But if an act protected by 31C with a nexus to 39B and C still violates the basic features of the Constitution or basic structure of the Constitution, it will still be open to this court to say under Article 14 we hold the law to be bad. And that's the context, and that's the constitutional development my lords have, in fact, over the years. 1419 has been raised much higher than it was at this stage of the constitutional history. And therefore, I submit my lords today can declare that 31C is no longer there. I don't only rely on revival or all those doctrines. Today, I submit this court can decide that 31C is bad. 31A and B are already there. The two articles, part 3 and 4, should be read together. And therefore, in fact, and 1419 to some extent is available.